What is everybody? Welcome back to Truth and Transparency. Today is Friday, September, the 26th. This episode is Shanna Gardner's Jailhouse Snitches will be outed by name episode. If you guys have not been following the Jared Bridegan, Shanna Gardner case, February 16th, 2022, Jared Bridegan was gunned down, an ambush shooting he was getting out of his car to move a tire in Jacksonville Beach area. An investigation would span the Jacksonville Beach Police Department, the Sheriff's Office, ATF, Federal Bureau of Investigations as well. And there would be an arrest in August of 2022 that was for a traffic violation, which led to the arrest of Henry Tennant as a murder for hire plot with the new husband of Shanna Gardner. Shanna Gardner was the ex-wife of Jared Bridegan. But Shanna Gardner has Jose Baez and a legal team that is obviously very good, very detailed. And Jose Baez came out and said that Shanna Gardner on June 21st, 2024, came out and said that Shanna Gardner is innocent and that she wants to clear her name. And so this episode, we're going to be breaking down. Jose Baez called it back in June of 2024 that the state has no problem lying. The state, there was discovery issues. Then they put a detective on the stand, ask him questions, knowing that he's going to lie about the answer, not reveal exculpatory discovery, not make police reports, not record witness interviews. Again, all of this is to keep Shanna Gardner from making bond and to be out on bail so that she can help in her defense. And he said that the next thing you can expect is we're going to have these jailhouse informants. You know, if she's not there, there can't be these quote unquote jailhouse informants that will come forward and will spout out that Shanna Gardner said X, Y, and Z. Well, filed on September 19th, 2025, so just a couple days ago, the state's 8th supplemental discovery exhibit. This response meets the requirements of Rule 3.220B, Florida Rules of Criminal Procedure, and provides answers in the same order as required by the rule. In this filing, Jose Baez will be proven true when the state says they have now Category A witnesses that go by the name of Serena Dent, Esone Duncan, Lauranda Ellis, Teresa Connor, all of whom are in the Duval County Jail, and then Category B witnesses who are Sissy Adams Jones, who is the attorney for Serena Dent, Matthew Lafrano, who is the attorney for Esone Duncan, Jay Forrest, who is the attorney for Lauranda Ellis, and Michael Bosson, who is the attorney for Teresa Connor. Now, I say those names the way that I say those names because Teresa is spelled Taresa. Now, it is Fangirl Friday. Let me explain. I am going to fangirl over we're going to laugh a little bit. These four witnesses, they all speak English, okay? After this filing, 4 witnesses in jail, then comes out two more witnesses, Category A witnesses, Ana Milana Rosa Palasico, Claudia Martinez Pardo Lopez, Spanish-speaking Duval County inmates. 6 witnesses are just added, as in like last week, who are going to be jailhouse informants against Shanna Gardner. I said, oh my gosh, you got to be kidding me. 6. 2 of them Spanish-speaking, and Ana Palasico and Claudia Lopez, they are claiming that Shanna Gardner was speaking Spanish to one of her cellmates and telling them something in Spanish. Well, I have sources that say that Shanna Gardner doesn't speak Spanish. Okay, no hablo español. No, nothing Espanol. Okay. And in fact, Mario Saldana would speak Spanish with his family and his friends, and Shanna Gardner would get so frustrated about it because she could never understand what he is saying and his friends are saying. Now, I pulled up every single witness and I said, I want to know about these ladies. Oh my God. First of all, not a single witness remembers when Shanna Gardner made these statements. The state claims that the statements made by Shanna Gardner, too, we're going to start with Serena Dent. Well, who is Serena Dent? Well, take a look at this. Serena Dent, and I had to do like a double take, no knock here, but the third arrest made in connection to the man who was strangled and shot in Riverside home. Serena Dent, 25, charged with accessory after the fact. Take a look. Well, maybe this isn't gonna.
In more local news, the third arrest has also been made in connection to the murder of a Riverside father. Police say Stephen Lindsay was strangled, shot, robbed, and left for dead inside his home back in August. 25-year-old Serena Dent was taken into custody in Texas and just extradited here to Florida, now charged with accessory after the fact.
Okay, so I say, Bella, hey, you got to come see this. I said, why would Shanna Gardner be housed with male inmates? She's like, what? She's like, Serena isn't a man. I said, oh, you don't think? She's like, no. I said, well, this seems really off to me. Well,
in November, police arrested Rico.
Serena is a female, but could have fooled me.
Stinson and Cameron Stewart were both facing multiple charges. Reporter Renee Beninati, she's joining us live outside the Duval County Jail, where all three are locked up this evening. Renee?
Tarek, I talked to Lindsay's daughter, who says this news is bittersweet. She's thankful these arrests have been made, but she knows it still won't bring her dad back. Stephen Lindsay's loved ones getting some answers with a third arrest in connection to his murder. 25-year-old Serena Dent is now charged with accessory after the fact. Lindsay's daughter says this still doesn't fill the massive void in her life.
You don't really heal from this kind of grief. You just have to learn how to live with it.
In August, police say the 73-year-old was found strangled, shot, and left for dead inside his Riverside home. Investigators say his house was ransacked, with items including his laptop, checkbook, and Honda Accord missing. What did your dad mean to you?
He was one of my best friends. He was a good dad and a good person. He was the funniest person I've ever met.
An arrest report states surveillance video captured two men, Rico Stinson and Cameron Stewart, going into Lindsay's home. Police say that footage shows Dent later going inside before all three walked outside with a suitcase, taking off with the victim's Honda.
$9,000 and a Honda Accord is what they took a man's life for, my dad's life for.
Stinson and Stewart were taken into custody in November, but Dent remained on the run until now. Her arrest report states detectives pulled her cell phone data, which showed pings at Lindsay's home at the time of the murder. Police say they also talked to Dent's sister, and she identified Dent as a person captured in that surveillance footage. What message would you have to these three people?
I'll see you in court, and I want to look them in the face, and I want to see some sort of recognition of the magnitude of what they've done.
Wow, $9,000 going into, I mean, I'm assuming, how do these people know who Lindsay is? Anyways, so statements made by Shanna Gardner to Serena Dent have been redacted at this point, but Serena Dent is unsure of the time and date that Shanna Gardner made these statements to her, but gives an approximation of around the spring of 2024. All statements were made in the Duval County Jail. Interesting that they are now going to say that this happened in the spring of 2024. Jose Baez had no idea about any of this, right? comes out and tells the world June 21st, 2024, which would be like right after the spring of 2024, that, oh, I can tell you what we're going to see next. Jailhouse informants. People saying this, that, or the other to get their deals. Well, imagine that Serena Dent doesn't recall when any of this occurred, that Shanna Gardner spoke to her and whatever she's saying to her, she's going to testify. Serena Dent has pled guilty to accessory to capital murder and is awaiting sentencing. Her case number is whatever. She has pled with no negotiation, the state says, except her guidelines were waived. You want to know what that would mean? Your guidelines were waived? That means your sentencing. That's what the guidelines would be. What your minimum is. Kind of the same thing like Henry Tennant. Okay. Serena Dent has cooperated in her accessory case, and there would be a legal basis to depart from the guidelines. Serena Dent's introduction of contraband case was dropped in exchange for her plea. So they're like, Nelson's basically saying, who's the DA, their prosecutors are saying that, hey, that contraband case that was dropped, that has nothing to do with us, that was dropped in exchange for the plea that was happening in the accessory to capital murder case that I just showed you guys. Serena Dent has no other criminal history and has not cooperated in any other cases. Now, moving on to witness number 2. Her name is Esone Duncan. Esone Duncan. And I was like, okay, well, what has Esone Duncan done? How did she find and land into the Duval County Jail? And so going to Esone Duncan's report here. Well, Esone Duncan, again, this is redacted as for right now what Shanna Gardner told her. But the state says as followed. Esone Duncan was unsure of the time and date that Shanna Gardner made these statements to her, but gives an approximation of around the spring of 2024. How convenient. Again, nobody knows when any of these statements were made to them. All statements were made in the Duval County Jail. Esone Duncan has pled guilty in cases 16-2021-CV006593, and then another one, without a negotiated sentence. Miss Duncan has also cooperated in case number blank blank blank. Miss Duncan also has a pending criminal case in case number blank blank blank. And Esone Duncan, Jacksonville Sheriff's Office murder investigation leads to multiple arrests. Timothy Smith, Jordan Hodge, and Esone Duncan. If you have information regarding this incident, please contact the Jacksonville Sheriff's Office. And then, so this could be found on Facebook. And I was reading about it. So on Sunday, January 24th, 2021, at approximately 9 p.m., officers responded to the 5,000 block of Shenandoah Avenue in reference to a reported shooting. Upon arrival, officers located an adult male who appeared to be suffering from at least one gunshot wound. The victim was transported to a local medical facility for treatment. However, he ultimately died as a result of his injuries. Detectives from the violent crime and crime scene units responded to conduct their respective investigations. Due to the victim's passing, the homicide unit assumed the lead in the investigation. Through information received and investigative efforts, several individuals were identified as possibly being involved in the incident. As a result of the investigation, the following suspects have been arrested in connection with the shooting death of the victim. And one of those people was 22-year-old Esone Duncan, a black female. She was arrested for murder. Note that the suspect Hodge was located in Volusia County and will be extradited back to Duval. Photo attached is from a February 2021 arrest. Next, my favorite story here comes from Lauranda Ellis. Lauranda Ellis. Now, this is where I was cracking up at this story. Okay. Lauranda Ellis was unsure of the time and date that Shanna Gardner made these statements to her, but gives an approximation of early 2025. All statements were made in the Duval County Jail. Lauranda Ellis has a pending case number blank blank and has never testified before. She has a prior felony conviction in case blank blank blank. And then they redacted what she supposedly is saying that Gardner said to her. Well, I said, well, what's Lauranda doing? Like, how'd she get caught up in this, this mess? Well, so we go and pull up Lauranda. And I said, oh my Lord. Okay. So alleged thief uses twin sister's identity to avoid charges. Now, unless we got people that are mixed up, which we don't, but here we go. A woman gave police her twin sister's name when she was caught stealing chicken from the grocery store, police say. Lauranda P. Ellis, 36, was caught after her twin, Sharonda, was charged with theft, according to Bloomsburg officer Ryan Edgar. He used photos provided by Sharonda that show both women, which he then used to match Lauranda to store surveillance and body cam footage. Edgar was called to the Waste Market, 725 Columbia Boulevard, just after 5 p.m. on August 1st for reported theft. When he arrived, a loss prevention officer said a woman was reportedly spotted stuffing bags of chicken wings totaling $20 into her purse. She fled the store and got into a white Lexus being driven by a man, he told police. The vehicle was found a short distance away and stopped by another officer. The woman, who identified herself as Sharonda, said when she was confronted at the store, she told employees that she had to leave because she had a baby at home. She had intended to go back and pay for the wings, Ellis told police. Police later learned her twin sister lives in Florida and was not in the state when the theft occurred. Ellis, Park Place Village, was charged with making a false report, giving false identification to law enforcement, and retail theft. Lauranda and Sharonda. Oh my gosh. What? Lauranda, get over here. Lauranda and Sharonda. She was caught stealing chicken wings. $20 worth. What? Wait, what? You guys can't make this up. So Shanna Gardner, again, another black woman, Shanna Gardner is now making statements to Lauranda Ellis. I said, you can't, this is wild. Anyways. Next up, Teresa, Taressa, Connor, was unsure of the time and date again that Shanna Gardner made these statements to her, but gives an approximation of the spring of 2024. Oh, imagine that. All statements were made in the Duval County Jail. Teresa Connor has 3 pending cases. Connor has cooperated in her case number blank. We believe Miss Connor has 2 misdemeanor crimes of dishonesty from Georgia and Virginia. That's kind of important, right? Dishonesty, right? So the state goes on to say that any written or recorded statements and the substance of any oral statements made by defendants, D is any written or recorded statements and the substance of any oral statements made by the co-defendant, any tangible papers or objects, like this is all the things. And then there's relevant jail calls. There's relevant jail calls. Well, I have no idea how Shanna Gardner is making relevant jail calls to these people that, I mean, are in jail. I don't know. Maybe she's using their jail numbers to make calls. I don't know. Anyways, moving on. So those are the 4 English-speaking jailhouse informants that are going to be used. Allegedly, they disclose, the state says, here, guess what? A year later, these statements were made over like 2024 in the spring. We're disclosing this to you in 2025 in September that, hey, that's what these 4 people, like Shanna Gardner's just running around the jail and talking to these, badasses. I wouldn't, this isn't who you'd want to be like shooting the shit with. Maybe she's getting her hair braided. I don't know. Now, filed on the same day, September 19th, 2025, was the state's 11th supplemental discovery exhibit. This response meets the requirements of rules, blah, 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 and they are names and addresses of all persons known to the prosecutor to have information that may be relevant to any offense charge or any defense thereto, or to any similar fact evidence to be presented at trial. And this is where we get to the 2 Spanish-speaking individuals. Again, both of them were in the Duval County Jail, and that is Ana Molina Rosa Palacio, and then Claudia Marcias Pardo Lopez. One of these items is a letter titled, in quotes, it says, to Shayla and family, end quote. And it was 1/22/2025. So there's a letter titled this. Statements made by Shanna Gardner to Palacio in Spanish. And then it's redacted. And then it's more redactions. So I'm like, wow, Shanna Gardner is in. She's got the best of attorneys, okay? The best that money can buy. And she's up in jail, the Duval jail, literally talking Spanish to the Spanish-speaking inmates and throwing up gang signs and getting jiggy with then the Black community as well. Because Shanna Gardner doesn't see color. And Shanna Gardner speaks Spanish, which she does not. All statements were made in the Duval County Jail while Lopez, Palacio, and Gardner all shared a cell. I said, wait, they have 3 people to a cell? Like, that's normal? So, making it seem like this is way more credible, because we're going to have 2 people that were there, not just Shanna, but there was these 2 Spanish-speaking women, and they were all just hanging out. So these 2 people are going to say the same exact thing, that, yeah, this is what Shanna said to us in Spanish. All statements, again, were made at the Duval County Jail, again, while they were all sharing a cell. Before ever meeting with the state about this case, Palacio pled guilty to second-degree arson. She pled guilty to second-degree arson before ever meeting with this case. Statements made by Shanna Gardner to Lopez, and that's redacted. You think that we believe you? By the way, I don't. All statements were made in the Duval County Jail while Lopez, Palacio, and Gardner shared a cell. Lopez has a pending case. The 4th Judicial Circuit State Attorney's Office is not the prosecuting authority on her case. Shanna Gardner, jailhouse informants. Other news. We have lots happening this month and next month with depositions being taken by the defense team. So a couple things happened since this trial has gotten pushed, back, which I think is interesting. Like, if you're going to use a jailhouse informant before the trial was going to be pushed back, why wouldn't you be revealing to the defense, hey, in I don't know, last winter, in 2025 or this past winter in 2025, why wouldn't you be giving the state, hey, this is what these girls said that Shanna Gardner said in 2024 in the spring? Like, how are you ever planning on using those people if that would have went to trial like it was supposed to go to trial here in October? So a couple things. Mario Saldana, he has his own defense team. His defense team said, hey, we need, you guys collected a beer can at the scene, and we are asking that that beer can be tested for DNA because they never tested it. So why would Mario Saldana be asking that a beer can be tested at the crime at the scene? If it was his, or if he thought it could be potentially anybody's. Thought that was interesting. And how about this? Why didn't the state ever test the beer can before they ever had any suspects? They took it into evidence. They just never tested it. Okay. Now, depositions. Shanna Gardner's defense team, as well as Mario Saldana's defense team, they have been taking lots of lay witnesses and their depositions. Just this April, Casey Bennett, Robin, William Harble. Then in June, they deposed 4 police, which were Special Agent Mutz, Jacksonville Beach Police, Filbert, J.D. Chodat, Jacksonville Beach police officer, and then Cullen. And some of those people are the evidence, part of the CSI. They were collecting the evidence at the scene. And I'm telling you, a couple of those people right there at the end, they decided to make, hey, we're just going to take apart this door to get to the bullets that we believe, but entered the door and blah, blah, blah. And it's going to come out that these angles that they were saying these shots were at, Jose Baez is going to have a lot to say about that. Next, this October, just next month, holy crap. Here we go. The defense will be taking in-person depositions of Adam Bridegan, that is Jared's brother. Justin Bridegan, that is Jared's other brother. Elizabeth Smith, who is the state plans on using to talk about what Shanna and Mario have ever said to her, to show this beyond interesting dynamic of a relationship, because Elizabeth Smith is going to basically testify that Shanna Gardner wanted to be a porn star and that Mario Saldana was going to be her manager. Wow, right? Talk about coming from the Mormon church to, woo, yeah, Mario, make me a porn star. Meanwhile, you have all the money you could imagine, but it's not about the money. I just want to do this at home with my kids. Meanwhile, I'm baking. Meanwhile, I'm opening up a bake shop and baking cookies and muffins and cakes for little kids' birthday parties. On the side, I want to be a porn star. Awesome. We have a couple other names again for October, and they are lay witnesses for the most part. Next, Friday, October 17th, we're going to bring in 6 more witnesses on October 17th. Again, lay witnesses, and Taylor Lees, Cody, Chelsea, Lauren, Matthew. We have Lindsay. We have all of these people that personally knew Shanna Gardner, Mario Saldana, and I am so interested to hear from Chelsea, because Chelsea and Cody, brother and sister, they are going to allege that Mario Saldana drugged them at a bar, and then for the purpose to bring Chelsea, the sister of Cody, back to their Shanna and Mario's house so that they could have playtime and we can record and get Chelsea naked and take videos and pictures of her. And again, I don't know how this has anything to do with Shanna Gardner. This was all about Mario and him, whatever he was doing with Chelsea, who was naked. Then Cody comes and picks up Chelsea, who was still naked when he came to pick her up after she left with them from being out and about. And then she went to the hospital and they like tested her and she didn't have any drugs in her system though, but she was still adamant that she was drugged. And Shanna Gardner actually texts her or messages her the next day and says, hey, what's up? How are you feeling? And she's like, I have no idea what happened, but I blacked out. And you guys, like, she didn't say you guys, right? She was like, somebody put something in my drink. And Shanna was just like, I think you just were drinking a lot and nobody drugged you. You were just trying to help you. But then here comes Mario, and Mario is a filthy, filthy man. So this case is going to be just all. It's just going to have everything. Also filed September 19, 2025, we have state's 10th supplemental discovery exhibit. And here it had to be redacted, like almost like most of the piece of paper. And it was category A witnesses. And these were all statements. And what I'm assuming here, it's jail calls and letters. And it has to do with jail calls that Mario made, jail calls that Gardner made, and then jail calls from Tenon. And then there's a couple receipts of the Jacksonville Police Department, like custody records. But it all had to be redacted. Anyways, we finally get on September 19th. I've been waiting for this one. I can't even believe this. I should use Hector, but I will during the deep dive. The state's 12th supplemental discovery exhibit, ready for this? Category A was computer forensic unit examiners. This is the expert who provided the raw extractions and reports from the items that needed it's all digital basically. And this is going to be a Jacksonville Sheriff's Office. The name is H.M. Quintana, last name. There are 14 items. So there's 14 raw extractions. And the defense is just now getting these reports on September 19th, 2025 for a case from 2022. And then Mario was arrested in 2023 in March. Shanna Gardner was arrested in October of 2023. You are just now getting the reports of Apple iPhone 13 Pro, Apple MacBook Pro, Apple MacBook Pro, Apple iMac, MacBook Pro, my Passport external drive, Lacey external drive, that's the name of it, Samsung Galaxy Note 20, Motorola Moto G Pure, CoolPad Legacy, Apple iPhone 14, Apple iWatch SE, LG K500, and then a Google download. So those 14 items, they come in the form of reports that whoever did the item, and there's the SAO number, and then there's a Jackson Beach PD number, and then there's a Jackson Sheriff's Office CFI number of where you can basically find these items. So they're linking it all. Here it is. And then the one thing that they redacted, which I just cannot believe that they would redact this is ridiculous, is the associated person with each item. The only person that they're not redacting is Henry Tenon, and he has one of the items, and that is item 13. His is the LG K500. Okay, and so it's a phone, in my opinion, it's an LG phone. But all the rest of the 13 items, we don't know who they belong to. However, the raw extractions all came from the Jacksonville Beach Police Department did no raw extractions. So they never did any extractions. So the extractions were either done by the Jacksonville Sheriff's Office or special agents, the ATF people, the feds. Okay. And again, there must be some type of a mistake here. Okay. Because when I turn it over, it's telling me that Henry Tennant also has the cool pad legacy because they didn't redact Tennant's name on this side. So when I go back and flip over, the cool pad is number 10. And so I don't know why they said that they don't have the name Tennant redacted here. It shouldn't be redacted. So I'm able to fill that in. And number 13, which was Henry Tennant's LG K500, they did a physical and they did a full file system. And I knew that. But the way that they say in the report that they said that they couldn't do any type of extraction, like they couldn't get into it. Then somehow they were able to do the physical and then they do the full file system. And I mark my words right here. Every time that you do an extraction, you're going to lose something and you're going to lose data. And so that will be an argument with whatever the full file ended up throwing up there. Because I just don't understand why you wouldn't just do a full file system off the rip. Why would you not do that first? If I just don't get it. Who cares if it takes a little bit longer? Okay, if it's a isolated targeted attack, right? Like Jared was ambushed. Let's make sure that we don't lose any data, right? So, hey, it may just take a little bit longer, especially when you're just taking 3 years to get, I don't know, here's the report. So yeah. Anyways, all of these extractions, the Motorola Moto G Pure, I cannot wait to find out who those belong to, these Motorola Moto G Pures. That was the only other device where 2 extractions were done, which was one was an advanced logical, and then they did the full file. Again, going to be really, really interesting. Shanna Gardner has a couple of items here, I believe. But if John Biggerstaff is involved, which I do believe he is, and Juan Biggerstaff is involved, it's like they're accessories after the fact in a way. But if you believe that John Biggerstaff's gun was used in this commission of this crime, that gun was in the possession of Juan Biggerstaff, who is a police officer in Texas. He came to town for his own personal wedding on the weekend of this murder that happened on a Wednesday. And then Juan Biggerstaff gets married on a Friday, or like the rehearsal dinner was Friday, then the wedding was Saturday. Can you ever imagine that you would be involved in a murder that is happening just days before you're getting married? Absolutely crazy, right? Telling you this case is going to be wild. All right. Again, I told you guys that the notice that the defense team requested for DNA, and that deadline was March of 2025. So ASA Stifler has indicated that she gave the lab a testing deadline of March of 2025. So I'm curious what results came back on the DNA testing done on it was a Busch beer can. A Busch beer can. And the team that was asking for this to be done, so the state never did the testing of the Busch beer can, comes now the defendant, Mario Fernandez Saldana, by and through his undersigned counsel, and hereby notifies the court of the defense's request for DNA testing and the state's agreement to have such testing conducted. Thus, the defendant states the following in support of. So, number 1, on February 16th, 2022, the night of the murder, the alleged victim in this case was killed in the area of Jacksonville Drive and Sanctuary North in Jacksonville Beach. I don't know why we're saying the alleged victim. Isn't it just the victim? The alleged victim? Number 2, while investigating the scene, evidence technicians collected 1 Busch can from the side of the roadway. And then 3, in reviewing the discovery provided by the state, the defense realized that the Busch beer can had not been submitted for DNA testing. Thus, the defense counsel asked the state if they would submit the Busch beer can for DNA testing, and the state agreed. ASA Stifler has indicated that, like I said, that was the deadline was March of 2025. And one would have to ask themselves, you collected it for a reason, and that wasn't of high priority to go and get the beer can DNA tested, which was like right there off the side of the road. Because if you think that somebody is lying in wait for an ambush, right? After they would have done all these interviews, they get to interview a couple people, associates of Henry Tenen, and they talk about the type of beer that they drink and the type of beer that Henry Tenen drinks. And guess who drinks Bush? Allegedly, supposedly Henry Tenen. Now, I'm going to play some clips, and then I'm going to end on, I have the, there was a deposition done, and this is an ATF agent. And I'm going to play a couple clips from Jose Baez, and then I'm going to read you a couple questions that were asked of this ATF agent during a deposition. And then I'm going to read you a couple questions that was asked of the other special service or Secret Service personnel that they employed to do the Taint team. I'm going to read a couple questions that he was asked and his answers. And it's wild. Here you go. Take a look. Take a listen.
So that was an outright lie. In addition to that, no other detective spoke with Miss SL. It was Detective Johns who in fact spoke with Miss SL. That was his second lie, and that was upon being pressed. Now these are clear, unambiguous, straight up lies made by the lead detective involving a critical witness who was allegedly being solicited for to hire a hitman for murder. As it turns out, the actual truth was that this was a running joke. Dismiss the state attorney's office and disqualify them. As we know, this is not their first brush with incidents in this case, and she can also give us reconsideration for the bond hearing for which we're asking. We're asking for Shanna Gardner to be released, and that of course is one of the remedies that we're seeking as well.
And the individuals that have come forward that would allow you to file this motion, they would speak publicly if necessary.
If subpoenaed to testify, they would testify to the truth of what they're saying. Yes.
There have been hearings in this case to talk about discovery and things like that moving forward after the issue.
That was his second lie, and that was upon being pressed. Now these are clear, unambiguous, straight up lies made by the lead detective involving a critical witness who was allegedly being prior to a critical hearing, and then later on afterwards doing it again even more. As recently as yesterday, we got more statements that allegedly occurred during the secret meeting that was non-recorded. So folks, I employ all of you who are here to, we're trying to do our job. We want you to ask the tough questions. Don't take the guided tour. This case is not as...
Boom. Don't take the guided tour. I love it. I am actually working on a new intro to mash up with my old intro with the same sound and the same music, and everybody loves it. So Jose Baez is going to be seeing a lot of screen clips from that. But right there, don't take the guided tour. Ask the tough questions. This case is not clear cut what they are saying. Jose Baez comes out and says that Shanna Gardner is innocent and she wants to clear her name, right? Well, we've heard that in the Brian Culver case, right?
Simple and as open and shut as it has been laid out to be. You have only heard one side of this case and what's coming out of it. reeks. And I think all of you, I think it's your journalistic responsibility to seek out and ask them, why are you putting on a police officer who's lying on the stand? Why are you allowing that to happen? Why aren't you recording meetings with very important critical witnesses? Why are you not getting these statements completely locked down? And ladies and gentlemen, I will tell you, there's a very good reason. And the reason is an obvious one. So I would ask that all of you, and even those who are listening, to seek out and ask these questions and hold them to their level of professionalism. And I can tell you this, it gives me no pleasure to stand here and do this. None whatsoever. I hate it with every being, every part of my being. But I will do it. I will fulfill my oath as an officer of the court and as the lawyer who's been entrusted with Shanna Gardner's life. They're not going to get away with lying in the courtroom. We're not going to stop until we seek justice in this case. They're not going to get away by creating evidence. And we're not going to allow that to happen in this case. I certainly hope that if there's any ambiguity.
There we go. Okay. So, dude, it's so true, right? Now, here we go. So I went ahead, printed off. These are depositions that can be used in the trial, and they will be used in the trial. So how this all played out was when Shanna Gardner and Mario Saldana were they lawyered up right away after Jared's murder, and they just did everything through a lawyer. They still had their interviews, and in fact, they didn't even bring their lawyer with them for their interviews at Jacksonville Police Department. Okay. But the lawyers told Jacksonville police that, hey, we know that you guys are going to be probably doing I don't know, your due diligence. And we just ask that you get a taint team on this immediately, because if you're going to be taking any of their devices, any of their communications, here's a list of our lawyers that each of them have. And we ask that somebody goes through this material before then it gets into your hands so that it removes the client attorney privilege information. So with that said, back a year or two now, there's been a bunch of obviously filings of motions. And so we get to the point of the defense team is like, we have some problems. So they go ahead and they call in after it was denied. Okay, so Shanna Gardner, it was denied bail because of the testimony and the evidence that was presented, right? But also there was issues going on with discovery. So in these depositions, the motion to disqualify the 4th Judicial Circuit Office of the State Attorney. And it ends up being, I don't know, it's 63 pages. Then the state responds to the defense's motion to disqualify. And in that response, this is what the hearing was prior to ever then having the bond, because the bond had to come second. Stifler says, no one from the prosecution team or the state's attorney's office reviewed any privileged emails or text messages. Courtesy, cooperation, integrity, fair play, and abiding by a sense of honor are paramount for preserving the integrity of the profession and ensuring fair blah, blah, blah. First statement that Stifler made. Second statement that Stifler made. Stifler had to take the stand. Second statement. The state obtained an independent agent from the Secret Service, and in quotes, we're going to refer to him as agent, to act as a taint agent for all the devices and all the downloads. All. There is no ambiguity. It's all. Every download, everything, we had a Secret Service person doing the taint team. Okay. All returned data was sent to the agent, who removed then all the attorney-client communications, which included emails and text messages. The agent used a list of provided names, phone numbers, and email addresses from both the law firms. During the investigation, the state only reviewed the detainted device data received from the agent. Okay. The state also obtained a Google search warrant for Saldana, which resulted in a return with multiple folders for Google categories, one of which was titled emails. The state, in quotes, walled off the file titled emails in each return until the data could be sent to the Taint agent, period. The emails obtained from the Google search warrant are still in the process of being reviewed by the Taint agent. This was filed on back in November of 2023, November 29th. Okay, that date's going to matter. However, the other Google files were reviewed, which included photos, videos, and documents. Within one of the file folders, the Google search return for Saldana, there was a documented title name, and it was listed as confidential communications, which contained a spreadsheet with text messages between Henry Tennant and Saldana. There were no attorney names, phone numbers, or emails listed on the spreadsheet. There were no attorney-client communications included in the file folder or document. The reason this is coming up is because Stifler walks up to Mario's attorney and says, hey, we have really incriminating information on your client. Like lawyer talk, you know? So next, the state utilized, it's called NextPoint. NextPoint is a cloud-based e-discovery and document review platform to create a portal where the data could be uploaded once it was detainted. NextPoint sent a team to assist the state in uploading the discovery onto the platform. NextPoint wanted to use an original source, that means raw is the original source, as much as possible for the uploading process, which means that they would upload the data from its original source rather than from a copy off of the original source. NextPoint inadvertently uploaded the original source of the search warrant returns for the Google data as they had been stored on the device's computer, which were unredacted, and they uploaded the detainted search warrant returns. Whoa, right? Additionally, the email folder is encrypted in such a way that even if open, the contents of the folder cannot be viewed without running it through a special software to review it. Otherwise, it would just be raw data. Regardless, neither the state nor law enforcement have reviewed any attorney-client communications. This fact could have been easily discovered had anyone from the, Mario Saldana team over there just bothered to ask us. We would tell them that we did not look at anything. We couldn't. Okay. Now this is where it gets good. So I'm reading this. I'm making my little notes. Stifler is just writing away, typing all of this stuff up. The state also confirmed with the Baez firm that although the data had been downloaded, only police reports had been viewed and no attorney-client emails had been viewed. Although it is the state's position, which is argued below in greater detail, that an evidentiary hearing is not necessary because Saldana has failed to carry his burden in establishing actual prejudice and thus has failed to demonstrate grounds to disqualify the prosecutor or the state's attorney's office. Should this honorable court disagree, NextPoint can testify about user downloads and reviews from the platform. Saldana was alleging that they needed to be disqualified because they reviewed stuff they shouldn't have. Clearly that came because of the prosecutor telling his lawyer what they said, And number two is Saldana has the burden of proving the existence of attorney-client privilege in the first place. And then next, Saldana has the burden of proving prosecutorial misconduct. You have to prove that. Well, yeah, we need an evidentiary hearing to prove that, right? And then Saldana has the burden of proof to prove actual prejudice. And again, that's why we're asking for an evidentiary hearing. Disqualification of the entire office would violate the separation of power, the power doctrine. And so here we go. Now, they have this hearing. They have the hearing first. And everything that's in this motion, Stifler has to get up on the stand and testify. So she's called to the stand and she testifies. Then after the hearing, and the state or the judge comes back and she's like, well, yep, you're not going to have access to, basically they're not going to be disqualified, but you're not going to be using anything from the items that were mentioned. Basically the defense won and you're not using that shit. Okay. And the way that Judge Kite looked at it is just like, this was just like, what poor judgment, like, what are you doing type of thing. After this hearing, the defense teams go and depose these special agents, Agent Butler and special agent, or I'm sorry, and Secret Service agent Angel, whatever his last name is. First question that I'm going to highlight here, asked at this deposition. Oh, so good. Question to Angel, who's the Secret Service guy. Question: do you know who Lindsay Butler is? Answer: no, I don't. Agent Butler ran this investigation from ATF. If Agent Butler is running this investigation from ATF, okay, and has to get then the stuff to the Taint team, who this guy Angel is, okay, you'd be communicating. Like, I have to get you this shit, right? Question: do you know who Lindsay Butler is? No, I don't. Did you work with an ATF Agent Butler in this particular case? I've heard her name. I know there was some, I believe she called me asking for me to do a Taint review on something that wasn't pertaining to any of the devices that I had examined. And I explained to her that that wasn't my role. That was my position. Lindsay Butler is asked, did you ever contact Angel? No. What? You never asked him to detaint anything? No. So one of them is not being truthful, right? Next question. And after reading an enormous amount of communications in this case, my question is, did you receive the entirety of the Google returns? Or did you just get pieces of the Google returns? More specifically, a file that was titled email? Answer: I don't recall the specific contents of each folder. I know there were numerous folders that came back from the return from both accounts. I believe there was one entitled emails. Question: okay, well, and if you didn't receive them until August of 2023, that's when you said you received them, August of 2023, it's fair to say that you could not have filtered anything out prior to that, right? If you didn't receive something until August of 2023, then you couldn't start to detaint, go through and filter. Correct. And he says, correct. Well, when did you finish filtering both Google returns? And he says when he was done. And he's like, okay, well, let me ask you this next question. If I'm receiving on 11/29 of 2023 from the prosecution saying that they're not done with the Google and they can't give it to me yet because it's still being detainted, you are just telling me here in a deposition that you've been done since when? You turned everything over September of 2023. So would she be lying? Like, what? And he's like, when did you first receive any cell phone material? And I'm going to use that broadly. If that's a jump drive or an external hard drive or an actual cell phone, a Google return on the hard drive, anything. He says, it was at a meeting that I received on the 27th. So February 27th, 2023 is when this all started. And did they hand deliver it to you? Yes, they did. And what was the hand delivered to you? we had received cell phones. Okay, so just so we're clear, Mario and Shanna Gardner were both raided in February of 2023. Not arrested yet, but their shit was taken. Of their phones and their devices. Again, Mario gets arrested in March of 2023, and then Shanna Gardner gets arrested in October of 2023. But in February is when they served the search warrants to take the devices that they went to their homes and did. And so he said, yep, there was a meeting for me to come in, and February 27th is that meeting. And they hand-delivered it to you? Yes, they did. And what was hand-delivered to you? Well, we had received cell phones. We had a Samsung Galaxy A13, a silver iPhone, a T-Mobile, all this stuff. Okay. At some point in time, at this point in time that I'm talking to you about, I just want to redirect to the beginning part of 2023, that February. Okay. Yes, sir. I assume going into March, you're now extracting from my client's phone, as well as colleagues are attempting to get into the phone, the iPhone, and the laptops. Is that fair to say? That is correct. Yes. Had you been provided a Google return? I believe the Google returns came to us later. I want to say that the Googles came in around maybe April or June. Okay. So in March, do you recall telling Detective Lamont that you would, this is somewhere between March 15th and March 23rd, that he's like, yep, I remember all of this stuff. Next question. And there are two Google returns that I'm aware of in this case. So one was received July 5th of 2022. It may not have been received by you. I think that that's when it was received by like the detectives. And he's like, yeah, sure. That's what I have. He's like, the two Google returns that I received were in August 21st of 2023. Okay. And he's like, yeah, that's when you received them. But do you know when the detectives got the returns because of the initial, when Jared's murdered in August or in February of 2022, then you're going and getting things all throughout it. So you weren't provided anything though until of 2023. So they weren't using like any type of taint team back in 2022. Get it? Good. Okay. If you have them in front of you, it may be possible that it was June 27th of 2023 that you got that stuff when Detective Johns received the return from Google. Entirely possible. But like I said, I don't know when he received them. I just can tell you when I received them. And he's like, I know that I received them on the 21st of that's when I started working on them. The 21st of August of 2023. So that would mean the detectives in 2023 had for over a month and a half these returns that were not detainted. Okay. All right. So he goes, question. And after reading an enormous amount of communications in this case, my question is, did you receive the entirety of the Google returns or did you just get pieces? Remember that part? He's like, okay, so I guess what my question is, and if you didn't receive them until August of 2023, it's fair to say that you could not have filtered anything out prior to that, right? That's correct. They're going to get so fucked in court. It's not even funny. Here's me saying, boom. Answer. It looks like September 6th and 7th were when I completed the 2 exams. And then on the 8th was when I delivered them to the Jacksonville Beach Police Department. Okay, question. In the state's response to our motion to disqualify their office, remember, they did this deposition after that motion hearing had happened and let the lies come in writing and let the lies come in on testimony. Then they deposed these 2 officers, these 2 agents, and it's just fucking... In the state's response to our motion to disqualify their office, I want to read you this, so maybe you can help me understand. This is from page 2, the second paragraph. The emails obtained from the Google search warrants are still in the process of being reviewed by the Taint agent. And this was filed in December of 2023. were you still working and filtering and reviewing anything after September of 2023? He says, no, wait, just that passed? November of 29th? Yeah. Were you still reviewing, filtering anything at that point? Because we're trying to get the goddamn discovery and you're not providing it to us. And you're lying and saying that, well, it's still being detaintized. And he's like, I know that we had the 2 MacBooks that Detective Padel had been working on still because we were unable to get into the devices. I just know that I completed my last exam, I believe, on October. No, actually, I'm sorry. That is a different case. For this case, I want to say that, yeah, this case, dipshit. Yeah, I was done with everything that I needed to do with this case. Like I said, 6th, 7th, and then I turned it on 8th of September of 2023. Okay. Whoo-wee. So you were the only person that was this. You were the only person that was the Taint team from the Secret Service, right? Yes. For just the devices that they assigned to me, yes. That's it. And to your knowledge, were any of those that Mr. Fernandez or were they my, Miss Gardner's? Whose were they? I believe they were Miss Gardner's. Okay. Do you know who Lindsay Butler is? Nope, don't know her. I do not know her. I know I don't. When you say devices, you mean reviews as well. Google returns? Yes. And the Google returns, I apologize, yes. And it was basically electronic media. I do not recall what it was that she, Lindsay Butler, was requesting a taint review of, but I ended up speaking with Detective Johns. I believe it was Detective Johns about this issue, as it was unclear as to why I was doing something other than electronic devices for a taint review. Lindsay Butler wanted him to supposedly do taint, to listen to these jail calls. Listen to jail calls. And then I can't remember if it was him or Detective Lamont said not to worry about the taint review, that I was being asked by the ATF that it was going to be handled a different way. He's like, he catches himself. He's like, and then I can't believe. And then he had to change it. He's like, I can't remember if it was him or Detective Lamont. I couldn't believe that they were telling me, hey, don't worry, we're just going to handle that stuff a little bit differently. This guy is just spilling the tea in this deposition. So your understanding is the whole point of your work was to make sure that no one else besides you, for the devices or the returns that were first extracted, were to have any access to any confidential communications or documents that you may have come across before it's turned over to the prosecutors and law enforcement, right? Yeah, you just confused me there a little bit, but can you repeat that? Yes. My instructions were in February 27th in 2023. My instructions were, yes, that I'm doing everything. They have me here because I'm doing it. Okay. Well, what's your training and background? Have you ever done this before? No. Is this your first time doing this? Yeah, this isn't what I do. Shut the fuck up. You guys can't make this up. William's just giving out gifts over here. Yuri's math teacher. You guys, this is crazy. This is crazy. Okay. Then let's go to deposition of Lindsay Butler. Now, when I found out that Lindsay Butler graduated with a master's from the University of Cincinnati in criminal justice, it broke my heart. Okay, I'm a UC Bearcat, all right? And I'm like, oh my God, Lindsay, come on. Like, Cincinnati is known for their criminal justice program. And here she got her master's from the University of Cincinnati. So on February 14th of 2024, Lindsay Butler gets deposed by the defense from 1:30 to 2:32, and it was via Zoom video conference, and it was recorded. Question. And what is your highest level of education? A master's degree? In what? Criminal justice from the University of Cincinnati? And after you graduated, did you attend a police academy? No, I did not. Where did you get your training in law enforcement intelligence? I guess I should say I haven't attended a police academy in the sense of an officer would go to an academy. I've received numerous trainings from various local, state, and federal law enforcement agencies. I did go to an ATF-led intelligence research specialist basic training course, which I guess would be equivalent to an academy. But yeah. Okay. And did you have any specialty in intelligence, like in forensic or accounting, or no? Miss Butler, how did you first become aware of this case from an employment standpoint? I was notified about the case, the homicide that had occurred. I believe I was notified that following day by an ATF agent. Was that formally to like bring you in on help on the case, or what was that, just like a water cooler, like just talk about like a local homicide? It was to bring me in to assist. Okay. Have you ever, and without specifically telling me which cases, have you ever worked on a homicide before here locally? Because one of my questions is why was ATF brought in day one? Like the murder happened on that night on the 16th, ATF's in on the 17th. She says, here, no, I don't think so. Not here locally. Okay. Is it typical for someone at ATF to be brought in day of or the next day after a homicide? Oh my God. And I was like, see y'all, this is what keeps me driving in the right direction. That was my question. And here it's coming out of the deposition on page 8. She says, I think it depends on the situation. The relationship that the local agency has with ATF. It depends on a number of factors, I would say. And that agency is it that asked you to assist. It was at Jack's Beach Police Department, the Assistant State Attorney's Office of the 4th District. Who asked you? I was asked to assist by an ATF agent. I'm not sure who initially contacted him, though. And so I was like, okay, yeah, you got to find out. And what did they ask you to assist with? I was asked to do some background research into individuals related or possibly related to the case. And I said, ding, ding, ding. Mario Saldana, so one of these names flagged something. And so here she says, I was asked to do some background research into individuals related or possibly related to the case. Question. Do you recall what individuals you were asked to investigate? Answer. Yes. I believe I was asked to look at the victim, Jared Bridegan. I believe his wife, Kirsten Bridegan, and then his ex-wife, Shanna Gardner, and then his ex-wife's current husband, Mario Fernandez. So you believe you were given those 4 names very early on in the case, possibly the day after the homicide? I believe so, yes. From that point on, were you working on the Bridegan homicide? Yes. So you would consider yourself part of the law enforcement team and network of folks helping in the investigation as of the day after the homicide? Yes. Answer, yes. It wasn't consistent throughout that time, but yes, I was assisting with the investigation. Question. There will be a time where we'll depose you again to go over everything that we possibly can with you. I was like, oh my God. He's like, but we still have some questions. Hang tight. But as far as like what you did like there, that's not what this is about, but we're going to depose you again. Don't worry. Question. Today, there is some limited scope, so I kind of want to fast forward to February of 2022. Were you involved in doing some analysis or intelligence on some devices in and around that time? It would have been 2023. 2023? I'm sorry. Okay. Yeah, 2023. And a number of warrants and subpoenas had gone out, right? And law enforcement was at some point in possession of computer devices, cellular devices, and Google returns in the year of 2023. Is that a very broad but accurate statement? She says, yes, that's correct. Okay, so 2, yes, on 2 separate dates, but it was for multiple accounts. Multiple. Like we had 2. So I'm sorry. For like account beginning in like, we received initial Google returns in, I believe, April of 2022. And a second return in June of 2023. And so that's what I'm trying to get at is, yes, in April of 2022, remember Jared is murdered in February. Then there was Google stuff that came back for search warrants. So that came back in April of 2022. And then when they actually did the search warrants and served them on Shanna Gardner physically and took her devices physically in 2023 in February, and then physically from Mario in 2023 in February. So that's like the 2 different time frames. And she says, and my notes indicate, I just want to make sure we're talking about the same ones. The Detective Johns issued a search warrant for Mario or Mr. Fernandez Google account April 14th of 2022 and received it July 5th of 2022. So that's what like they ask her, like, hey, I'm just noting, I just want to make sure that we're talking about. So Detective Johns issued a search warrant for Mario Google account in April 14th of 2022, and he received that in July. And she says, yes, that would have been the first search warrant for that account that I reviewed. No taint. Ready? Okay. She says, yes, that would have been that. Question. And then the second search warrant was issued April 3rd of 2023 and received the return June 27th of 2023. And she says, I believe, I'm not sure when the search warrant was issued, but yes, in June of 2023 was that return. Those are the 2 that you and I are discussing at this moment, right? Yes. Okay. When did you receive both of those returns for your analysis and intelligence? Like, when did you receive the returns? She says, the first one, I'm not sure. It would have been, I believe, shortly after the return was received from Google, but I don't have an exact date. That would have been in 2022, the first one. Okay. The second one, I received on June 29th of 2023. June. She received it in June. This is so good. They got him by the balls, man. So she says, I received June 29th of 2023. Okay. And how did you receive it? I would have received it from either Detective Johns or Detective Lamont. I don't recall which one, but one of those 2, because those are the leads. Here I say, boom. It did not go to a Taint team first because she isn't Taint. Now, that's right where I realized you have her. You, not her, because you have Stifler. Okay. And would you have received it hand delivered or mail? She says hand delivery. Okay. And in what mode or means would you have received it? She says typically they would bring a flash drive over and I would pull the information off of a flash drive. Question. And at no point in time did anyone tell you to be on the lookout or to avoid any client attorney privilege that just wasn't within your, purview? Well, I knew that I was not supposed to review any portions of that return that were believed to have been attorney-client privilege communication. And how would you know which portions would and which portions wouldn't? So within a Google return, there are probably upwards of 20 to 30 different folders that contain a variety of different things, which is accurate. So Google search history, account settings, things of that nature. The portion of the return that deal with email and email content are very clearly labeled. And so those portions of those returns were not, I did not touch them or view them in any way. So she's like, I just did not go into the emails. Okay. So, and I received an email from the prosecutor. The question is, at some point in time that said that you were walled off from email. Is that correct? Answer, walled off. I don't think I was walled off. Stifler is just sitting there listening to this shit in this deposition. Because she used the term, yeah, they were walled off from this. Like they couldn't even get into that shit. I don't think I was walled off. I don't think there was a folder that I knew to contain emails that I just didn't look at because I knew that it needed to be reviewed. So is it fair to say you had access to them? You just didn't know. You just didn't open them. Yes, it's exactly. Yes. Question. So if someone had written their lawyer a letter in, let's say, Microsoft Word and saved it in their Google Drive, it could be contained within the Google account in a subfolder that would not have been within the emails. You would agree with that, right? Yes. And that's just one example of a number of ways something could be saved and contained within a Google Drive, right? Yes. And if you had access but were instructed not to go into the email, you would have no way of knowing what was attached to an email and what wasn't attached to an email, right? Correct, because I had not reviewed the emails. Exactly. And at any point in time, were you made aware that another agency, the Secret Service, was going to go through Mr. Fernandez's phone, his devices? Have you ever called Miss Stifler? Yes. Why did you call her? I had called her on June 29th because I was reviewing the Google Drive files. I came across 2 documents that I was concerned or had a question about being potentially privileged. And in no way you would know, question. And in no way would you ever represent to yourself or you would ever represent to this court that you were a taint agent ever in this case, right? She's like, no. Question. And of course, again, those 2 documents I asked you earlier about more, generically, but there would be no way for you to know whether those were in an attachment to a lawyer because you weren't, I'm going to use the word walled off. I wouldn't use that word because you didn't think it was accurate, right? But you weren't walled off. You were intentionally not going to cross-reference what was contained in that email folder or the emails to the attachments, right? Because that's not what you were doing. She's like, the content folder, I wouldn't know if they came from an email because I wasn't cross-referencing because I didn't go into the emails at all. Okay. So at this point, around June 30th of 2023, there's no way for you to know whether what you're viewing in a Word document, right, actually came from emails. Right? She's like, yeah, right. This is how sneaky deaky deaky. Go back and read now for you guys. So that's a little section, basically catching her. Um, 63 pages. But going back to what this idiot wrote. Okay. This is what Stifler said to Judge Kite. Saldana has failed to prove every email at issue involved attorney-client privilege information. For example, the Google document that Dreiser alleges Saldana forwarded to his attorney that contained text between Saldana and Tennant is not a privileged document because no attorney was privy to the text at their creation. Okay. To the contrary, no attorney was privy to the text between Saldana and Tennant until they were transferred to the attorney, which was after they had been created and sent between Saldana and Tennant. The texts at issue are dated from approximately September of 2021 through July of 2022. Documents which are given by a client to an attorney while seeking legal advice are privileged in the hands of the attorney only if they were privileged in the hands of the client. Okay. This hoe, Stifler, this is what she's trying to argue. when they obtained Mario Saldana's devices and they downloaded his devices, in his devices, well, none of these text messages were there. Okay. Then they said to themselves, well, if we get his Google and get the Google Drive, okay, and we get into his Google, anything that was ever been saved in to your Google account through your Google Drive, even if you would have sent emails to somebody and you ever made attachments and those were downloaded and saved to the Google Drive, those are going to come up. And they're going to come up in two forms. They're going to come up under the email section, but they're also going to come up in other folders. Okay. And the state knew the reason they were going for the Google is because they were like, we think he deleted stuff. Okay. So the state is trying to tell Judge Kite that, hey, we never told them that we would use a taint team. We only told them that we would use a taint team for the devices, never for the cloud-based material. Judge Kite's like, what the fuck are you talking about? The cloud-based material is basically an image of the device that you went and seized. And so you think that there's not, like, your agreement only goes to the devices and not the cloud-based material that comes from the devices? How do you have the audacity to ever, like, literally make that type of an argument? I was blown away. Absolutely blown away. That's like really like this woman is making this argument. Stifler says that documents which are given by a client to an attorney while seeking legal advice are privileged in the hands of the attorney only if they were privileged in the hands of the client. No privilege having been accorded the emails between Saldana and Tenon when they were sent to each other. None can be conferred by merely transferring them to Saldana's attorney. Well, hold on one second. Okay. Order denying defendant's motion to disqualify office of the state attorney for the 4th Judicial Circuit and order granting suppression. This is how the judge saw it. Procedurally, both defendants have adopted each other's written and oral arguments. Both defendants' motions argue that the office of the state attorney for the 4th Judicial Circuit should be disqualified because Assistant State Attorney's Office Stifler, working on their case, committed substantial misconduct, which resulted in them obtaining privileged client-attorney communications. As a result, both defendants argue that they will suffer actual prejudice if the 4th Judicial Circuit Office of the State Attorney is not disqualified from their cases. Defendant Fernandez alleges actual prejudice because the state saw 2 privileged documents. One was the confidential information timeline, and 2, the confidential communications text messages between tenant and whatever. Defendant Gardner alleges that actual prejudice because investigators saw a privileged client-attorney communication and told the state about its subject matter. While factually distinctions exist between the state's conduct in each case, the arguments are so closely intertwined that the court deems it appropriate to address all the claims in a single order. And so this is what they said. Jared Bragin was killed on February 16th, 2022. On February 6th, 2023, law enforcement executed a search warrant on defendant Fernandez's vehicle and cell phone. On the same day, federal law enforcement agencies working with the Federal Circuit State's Attorney's Office executed a search warrant for Gardner's residence and vehicle. In the search, law enforcement obtained multiple electronic devices from both the defendants. At the time of the seizure, both defendants were represented by attorneys. Immediately upon notification of the seizure, defense counsels sought court intervention to protect privileged information. On February 7th, 2023, Shannon Day, defendant Fernandez's attorney, emailed a letter to Stifler warning her that the electronic devices seized by law enforcement contained statutorily privileged communications. Defendant Fernandez Exhibit 6. On the same date, Jesse Dreiser, defendant Fernandez's attorney, filed a motion for a protective order. Specifically, in defendant Fernandez's motion, he requested the court to enjoin the review of the seized devices until a neutral and detached magistrate special master taint team or filter team is appointed to review the privileged communications. While most of defendant Fernandez's motion was focused on marital privilege, paragraphs 6 through 9 discuss attorney-client privilege. On February 16th, 2023, defendant Gardner filed a similar motion for a protective order. A hearing was held on these motions on February 17th, 2023. The court entered an order dealing with the marital privilege issue, not the attorney-client privilege issue. The state assured the court and defense that an order was not necessary. The state agreed to, quote-unquote, remove all attorney-client privilege content from the devices. We're only here, we're going to do that. This statement or agreement is not accurate. To maintain the integrity of the evidence, Agent Nazario testified that he did not remove any of the attorney-client privilege communications. Nazario's deposition, page 26 and 38 through 39. Instead, if the agent deemed an item was privileged, he would just tag it, filter it out, and provide law enforcement with a report without the privileged content. However, the agent explained that he does not delete or remove it from the device. Nazario's deposition, page 26. All the information remains on the devices or the items of evidence. 3 USSS provided the taint agent, and no sanitized ATF agent from Miami was assigned to do a taint review. There is no evidence that the state informed the defense of the change in the taint agents. That's what her that was her footer was from Kite. The existence of this agreement was memorialized in footnote 4 of the court's order on the defendant's motion for protective order, which stated, the state has agreed that any communications protected by the client attorney privilege will be removed from the devices by a non-state third party prior to download. In this way, law enforcement officials will not be able to view the content subject to the client-attorney privilege. Counsel for both sides are working together to identify sending/receiving phone numbers, emails, blah, blah, blah. This was all done before anybody was ever arrested. Like, in response to this agreement, Stifler was provided with the contact information of the defense attorneys. Specifically, on February 24, 2023, Mr. Dreiser sent a letter providing the names and phone numbers and email addresses of 5 attorneys and referencing the agreement. That was when they did their brief, they had exhibits. That was Exhibit 9. On the same date, a list of attorneys for defendant Gardner was provided to the state via the email. ASA Stifler responded by email stating, "I'm going to proceed with the download of Mario's phone with instructions to LEO to delete, redact, remove the attorney communications. Due to the timing being a little later than anticipated, Secret Service will do the download but cannot provide a taint agent. So ATF is going to bring up an agent from Miami who is sanitized from the case to redact the attorney-client communications." This never fucking happened. She lied. If this is acceptable, great. If not, give me a call and we can discuss it further. In early February of 2023, U.S. Secret Service Special Agent Angel Nazario was asked to assist the Jacksonville Beach Police Department in extracting data from the seized electronic devices. On February 27, 2023, Agent Nazario was then asked to transition from downloading and extracting these items. I want you to now be, we're going to make you now the tank guy. He said this in his deposition. Agent Nazario had never conducted a taint review for a client-attorney privilege in his life and received no taint agent training. Again, he said this in his deposition. Intuitively, he asked for a list of the attorneys and other identifying information to search the extracted data from the electronic devices. All seized devices were to be filtered by him to remove attorney-client communications. Agent Nazario was instructed to do a content blind analysis of the data, where he would filter out any communications between a defendant and his or her attorney, regardless of whether the communication was privileged. So if it was just from that person, just blindly disregard it. Agent Nazario acknowledged that a client-attorney privilege could be discovered in other areas of the device or returns and was not exclusively to just emails in his deposition. He would cross-reference anything found in communications folders with any other folders in the cloud returns in case attachments were saved in multiple locations and filter it out. Agent Nazario was adamant that he did not alter the original evidence. Instead, he provided a filter report to law enforcement and the state without the client-attorney privilege information. Since the Taint team consisted of one federal agent and did not have an attorney assigned to it, any questions about whether a particular communication was privileged, especially ones that did not have the identifying information, would eventually flow to Stifler to make a final judgment call. Agent Nazario testified that he would direct his questions about whether an item was attorney-client privilege to either the lead detectives of the investigation or the ASA. Specifically, when asked about what he would do if he was uncertain of whether an item was a confidential communication between a lawyer and the client, Agent Nazario responded, "If I had any questions, I would reach out to the prosecutor, and that would have been Ms. Stifler, period." He initially contacted the lead detectives if he had questions about a message or a document. Later, Agent Nazario clarified that he was not asking the detectives whether an item was a client-attorney privilege. Instead, he asked the detectives to contact Stifler, and he was trying to keep them in the loop just of his communication with the state attorney's office. After 2 or 3 requests, the detectives told him to just contact her directly, leave us alone. When Agent Nazario would call ASA Stifler with questions about whether the communication was considered tainted material or privileged communication, he would describe the communication to her, and she would give her opinion. Hey, is this privileged or not? She's not supposed to know anything about this. I am letting everybody know how dirty Stifler is. This is, this is wrong. You know that you cannot have the taint guy coming to you and telling you and describing you what the information is, and for you to say, no, I don't think that's privilege. Come on, send it on back. Let me take a look at that. The agent did not record the number of times he spoke with ASA Stifler. However, he testified that it was approximately 2 or 3 times. Later in his deposition, Agent Nazario testified that he did not read the documents and only used a search to locate files or materials that could be a client-attorney privilege information. It is unclear from the evidence what the agent would have described to ASA Stifler to get her opinion about whether something is a client-attorney privilege. Now, on March 16, 2023, the state filed a 4-count indictment against defendant Hernandez, charging murder in the first degree, conspiracy to commit murder, solicitation to commit a capital felony, and child abuse. On March 22nd, 2023, defendant was arrested and held without bond. Unbeknownst to the defense attorneys and the defendant, at the beginning of April 2023, investigators obtained via search warrants information contained in the defendant's iCloud and Google Drives. They had no idea that they did this. The search warrant sought, quote unquote, any and all files and or content, end quote, for the defendant Gardner's Apple iCloud and Google Drive account data and defendant Fernandez's Google Drive account data. In the hearing, ASA testified that this data was sought in part to recover possibly deleted material from the seized devices. Wait, what? So it is an extension of the device, is what you just testified to. Love it. What an idiot. In late June of 2023, the search warrant returns were sent to the Bureau of Alcohol, Tobacco, and Firearms. Civilian employee Lindsay Butler to investigate, and later for Agent Nazario to filter. So you investigated all the returns first, and then he filtered after. Unbelievable. This is a judge's order. This is like, if when I was reading like Hippler's orders, this is like me reading a Hippler order, but this is from Judge London Kite, who I'm a fan of. I think she's super fair, and she's very thorough. She says stuff right from the deposition. She's not putting on her own little twists, and not making arguments that the state didn't make. She's not making their arguments for them. That's not how she operates. ATF Butler testified that she assisted law enforcement throughout the investigation and was assigned the day after the homicide in 2022. In 2023, ATF Butler was asked to assist in the intelligence analysis of the electronic devices and Google returns. Butler's deposition on page 10 through 11. She was asked to review 2 returns, the April of 2022 return and the June of 2023 return. On the second return, the lead detective hand-delivered the information on a flash drive for her review, which means that it didn't come from the taint of Angel handling it to her. Okay. Jacksonville Police, Lamont or Johns hands the ATF Butler, who's like basically on the same level as them in that capacity because they were both investigating the cases like detectives. So Johns or Lamont hands her, here you go. This is the return that we got from the search warrant. Wouldn't have been detainted, right? Okay, so ATF Butler testified that she was never explicitly told to be on the lookout or avoid a client attorney privilege information. However, intuitively, ATF Butler, that good old UC education baby, master's degree, University of Cincinnati, okay, she just knew that she shouldn't be looking at client attorney, like that's a given. I don't need to be told that. I was taught that shit. I don't need you even tell me that. So give a shout out to UC. ATF Butler. was copied on an email that shared attorney names and contact information. She avoided those email folders on the return. ATF Butler thought any email attachments would be contained in the email folder. She could not determine if an attachment was saved in another area of the return because she did not review the emails. ATF Butler knew that another federal agency, the United States Secret Service, was acting as the Taint team, and she admitted that she never reached out to the agency. On May 11, 2023, ATF Butler contacted ASA Stifler about a text message she had come across in defendant Gardner's iCloud return. She informed Stifler she had come upon something that was privileged, end quotes. ATF Butler testified that the privileged message was something that she should not have seen. That is the extent of the description of the message that she gave in the deposition. According to ATF Butler, she only revealed that it was a message from an attorney and did not disclose the content of the message to ASA Stifler. In response, Stifler told Agent Butler to cease reviewing the iCloud return until Agent Nazario had completed his review. What do you mean completed his review? He didn't even get the material. ATF Butler was given the same return to review after the Taint agent reviewed it in late May. He didn't review anything in May. ATF Butler could not confirm if the earlier messages was on the return the second time because she did not look for it. However, she did not locate any messages or information between defendant Gardner and her attorneys on the second review. On June 29, 2023, while reviewing defendant Fernandez's Google return, ATF Butler found a log of text messages between defendant Fernandez and defendant Tenon and a timeline drafted by defendant Fernandez. ATF Butler testified that she called and alerted the state about two potentially privileged documents. Two separate phone calls were on June 29, 2023, regarding the documents between ATF Butler and the state. She believed the documents could be significant to the investigation because the text messages, those document date was shortly after Henry Tenon's arrest. This is crazy. ATF, how could there be text messages after the arrest of Henry Tenon with Henry Tenon if he was arrested? How did he text him? How was Mario texting Henry Tenon after Henry Tenon was arrested? He never left jail ever again. Okay, I'm going to repeat that. Butler she believed the documents could be significant to the investigation because the text messages document date was shortly after Henry Tenon's arrest. ATF Butler described both documents to ASA Stifler over the phone. During the second phone call, ATF Butler confirmed that the documents were not emails and the location of the files on the return. Butler deposition. And what she is saying is that I had no way to cross-reference this because I didn't look at the emails. That's actually how that should be said. So I disagree with Judge Kai right there. She says, according to ATF Butler, these text messages and timelines were not located in any other location other than the defendant Fernandez's Google return. Butler deposition, page 23. However, ATF Butler testified that the defendant Fernandez had an application downloaded around the same time as the text messages, which could have been used to create the document. Exactly, because guess what this is from? His attorney, Fernandez's attorney, was like, hey, you need to make a timeline of everything. You have to start documenting all of this shit. Okay, make a timeline. Okay, because they're coming at you. And so I want you to be prepared and I need to know what's going on. So you need to make me a timeline and then email it to me. That's what this is. These idiots are over here like, oh my God, look at this. He's just writing out the timeline of the murder and all this shit. And it's like, no, his attorney asked him to do this. And it came actually from the email. And the email says all this, and it was attached in that email. But when Fernandez has downloaded it to the Google Drive, that's how the prosecution was sneaky and got it. And then are trying to say that it's not client attorney privilege. So this is showing us ways that the government is exploiting loopholes. It's what it's showing me. So ASA Stifler consulted other prosecution team members and told ATF Butler to send her the files because they had determined the files were not privileged. They just made that own determination. No Taint team did. They did. They're like, you know what? It's not privileged. Send it to us. ATF Butler emailed the two documents on June 30th, 2023 at 1:35 p.m. On June 30th at 3:32 p.m., Stifler forwarded Butler's email to Maserati, baby, and Wingard. On August 17th, 2023, the state filed a 4-count indictment against defendant Gardner, charging murder in the first degree. So she was charged literally 1 month and a half after this privileged information that they're deeming is like Mario writing out his timeline of and basically the murder. September 7th, on October 20th, 2023, defendant was arrested and held without bond. On September 7th of 2023, Agent Nazario sent an email indicating he finished parsing both search warrant returns. So the next day, he sent an email confirming that he dropped off the thumb drives y'all provided along with 2 reports and 2 DVDs with parsed search warrant returns from Google for Fernandez and Gardner, end quote. On September 27, 2023, Mr. Dreiser wrote a letter to ASA Stifler expressing concerns. I got some concerns about a conversation after a court date. In the letter, Mr. Dreiser told ASA Stifler that he was under the impression that the text messages were either deleted or hidden. Further, the letter states, the reason for my concern is not the contents of the messages between Mr. Tennant and my client, but in the manner in which these messages were obtained. The letter informed the state that the defense instructed defendant Fernandez to label any privileged information as confidential. Mr. Dreiser attached redacted emails from defendant Fernandez to his office showing one of the documents confidential. Timeline was intended for use by his attorneys. On September 28, 2023, ASA Stifler responded to Mr. Dreiser's letter with an email. In the email, Stifler wrote, we had a taint agent remove all attorney communications for both defendants and firms. The discovery we discussed was not attached to an email, did not show any attorney names or emails, and did not contain attorney-client discussions. The taint agent forwarded it to us for review. And based on what he advised, the taint agent basically advised, I determined that nothing that would suggest it was privileged at that time. The discovery was eventually uploaded to NextPoint, a platform for sharing information. In the state's response, footnote here 6, no information was presented in the evidence, depositions, or hearings about who uploaded the evidence to NextPoint. That's what I wanted to know, and they didn't get to it. Agent Nazario and ATF Butler were asked about their role in uploading data to NextPoint, and both denied that they participated in uploading the data. Nazario deposition and Butler. Both witnesses were asked about Brett Burney, who is presumably a NextPoint employee. Oh, Jose Baez going to eat that ass. Can't wait for that one. The agent denied knowing Mr. Burney. ATF Butler recognized the name as a contact for Next Point. ATF Butler assisted law enforcement with a chart of data to be uploaded, but she didn't do the upload. It's going to get so juicy. ASA Maserati wrote, in quotes, Next Point wanted to use an original source as much as possible for the uploading process, which means they would upload the data from its original source rather than from a copy of the original source to preserve the metadata that it included in the original source. Maserati continues by asserting that Next Point inadvertently uploaded the original source of the search warrant returns for the Google data as they had been stored on the detective's computer. What? So these detectives had access to the original shit untainted, or tainted rather, not detainted. Do you see how they just keep telling on themselves? These idiots. It's because when you lie, you got to keep trying to lie about it. Liars. I love it. It's in documents. In the state's response, the state maintained that no law enforcement agent or ASA reviewed attorney-client privilege emails. The state asserted that the files are zipped and compressed on a detective's computer. Additionally, special software is needed to view it. No, there's not. Otherwise, the state indicated that if the emails were opened without the software, all that we would be reviewing is raw data. In a letter, Defendant Gardner's defense team acknowledged that they reviewed attorney-client privilege communications of Defendant Fernandez via Next Point and stopped reviewing the information. Defendant Gardner's emails, call recordings, voicemails, and other communications were accessed by Defendant Fernandez's defense team. When the state was notified of the error, the state immediately shut down the Next Point platform. Shortly after discovering the aforementioned events, the defense team filed the instant motions before the court, and the state filed its response. The court conducted separate evidentiary hearings to address the distinct factual issues of each defendant. Defendant Fernandez's hearing was conducted on April 18, 2023. Shannon Day was called as a witness for the defense. Ms. Day testified that the defendant, Fernandez, retained her office legal services on August 23, 2022. That was the day after Henry Tenen was arrested, for the record. And he was arrested, though, in August of it was August 18th, 2022. But he was arrested for a traffic violation. Additionally, Ms. Day testified, she was the primary attorney tasked with reviewing the discovery provided by the state. Ms. Day testified Defendant Fernandez created both the text messages and timeline at the request of his attorneys. Additionally, Ms. Day stated that she had spent hours reviewing the discovery in this case, and that the text messages do not appear in any other location other than the Google Drive return. Ms. Day said that she has attended discovery meetings with the state, and that Stifler has confirmed that the state intends to use the text messages in prosecuting Defendant Fernandez. He made all this shit up. Wait, what's going on? What regarding Next Point, Miss Day said that all defense attorneys and other users had access to the information contained on the platform. Ms. Day testified that the attorney-client privilege emails were uploaded and users did not need to unzip the emails to be viewable, like I said. What liars. Dude, this is so nasty. An attorney from the Defendant Gardner's defense team exported all of Defendant Fernandez's emails. When the defense discovered this, the state shut down Next Point on or about November 14th, 2023. Regarding Next Point, on cross-examination, Ms. Day attested that there was no evidence that the state reviewed the emails uploaded to Next Point before it was shut down. There was no evidence of it, meaning like she couldn't testify that they had. You would have to actually call Next Point and do back-end search. You guys heading out? Okay, cool. In the Fernandez hearing, the state called Stifler as a witness. Stifler established that she is the lead prosecutor for the investigation and the prosecution of both defendants. First, Stifler testified that when she was notified of the Next Point upload error, she immediately called the platform and had it disabled. Additionally, she called members of defendant Gardner's legal team and requested them to stop any review of defendant Fernandez's emails. To support the state's position that law enforcement and the state did not view any of the emails, she had law enforcement's laptop examined by the Jacksonville Sheriff's Office Computer Forensic Unit. ASA Stifler testified that the forensic report showed that no emails were viewed by law enforcement. State's Exhibit 1. Is that right? Get out of here, man. Well, what computer did you use to do this forensic audit? ASA Stifler testified that during the investigation, it was learned that defendant Fernandez deleted information from his phone. She acknowledged that the internet-based storage would contain this information. How did you learn this information from the seized electronic devices and potentially other information related to the investigation? ASA Stifler stated that they sought communications between defendant Fernandez and defendant Taint. She had a proffered interview with defendant Taint and knew communications existed between him and defendant Fernandez. That's how she's saying that she knew. I got this proffered from Taint. ASA Stifler acknowledged that the state agreed with the defense to use a Taint team to conduct a content blind, which means it doesn't matter what it's in it, you're going to delete it. And this was a review of the devices. She stated that the Taint team was told to delete attorney-client privilege information from the devices. However, when the Google returns were given to law enforcement, they were instructed not to review email folders. ATF Butler contacted Stifler regarding the text messages in the timeline because of the title confidential based on the text message documents descriptions. ASA Stifler said that there was no indication that it was attorney-client privilege and that there was an application on the phone to download it. She confirmed that the text messages were not on the electronic devices. ASA Stifler indicated that the description of the timeline document seemed to be related to public relations and not attorney-client privilege. Public relations. What? ASA Stifler opened and reviewed the text message file. However, she did not open the timeline because, based on Agent Butler's description of its contents, she did not believe it was relevant. She just didn't believe it was relevant. The timeline wasn't relevant. Yeah, because you want to know what he wrote all about in that timeline? This is what was going on in the case. Like, this is what's happening. You know, and he's updating his attorney. It's like me notifying my attorney, hey, these crazy psycho obsessed people, this is when they're making videos and this is what they're doing. Here you go. On cross-examination, ASA Stifler admitted that ATF Butler was concerned about the two documents and sent a follow-up message to ensure she wanted the documents forwarded to the state. Are you sure you want these? Yep. Send them on over. Additionally, ASA Stifler acknowledged that Agent Nazario was not used to determine if the documents were client-attorney privilege, so she has to admit this. ASA Stifler testified the Taint agent would have likely deleted the documents because he was doing a content blind review. Yeah, no, don't send that to him. Send it over here. This is sick. On April 19, 2023, the court held defendant Gardner's hearing. Defendant Gardner adopted the exhibits and arguments of defendant Fernandez and submitted her exhibits. Many of the exhibits mirror those of defendant Fernandez. Among defendant Gardner's exhibits is the transcript of the hearing held on the motion for protective order, in which Mr. Cox argued, as we've said in our motion, and I brought a protocol that the United States Department of Justice uses for Taint teams. Although I think that Mr. Dreiser is not a fan of Taint teams, and I would say I'm not a fan of taint teams either. There's been too many articles that they don't abide by what they are supposed to do. But the first step is for the court to determine who is an independent reviewer of what seized, period. The independent reviewer needs the benefit of who would claim in review. It would be privileged communication to whom. Once that is done, you're sort of half don't so a half, like the other half, it goes to somebody who does the actual independent review and says that's not privileged, that is privileged, that can't be connected. ASA Stifler stated in the hearing on motion for protective order, quote unquote, the state's position is we agree that the state is not entitled or not necessarily entitled to, but we've agreed that we will just abide by a plan between the attorneys and the state in order to make sure that we don't receive or there are no disclosures of a client-attorney communications. This basically means when you're doing a blind content, like we're just going above and beyond. Hey, for us to do this, fine, we'll agree to it. Anything that has their names out. Defendant Gardner submitted an email from ATF Simons, whatever, on April 27, 2023, showing assignments of the iCloud search warrant returns. ATF Butler is assigned the period from August 6, 2020 through October 21st, 2021. Defendant Gardner also entered an exhibit showing on May 22nd, 2023, ATF Butler sent an email to ASA Stifler regarding a text message found on Defendant Gardner's iPhone. Unlike Defendant Fernandez, Defendant Gardner did not call any witnesses and did not request an in-camera review of potentially attorney-client privilege information. The state called Stifler as its witness in the hearing. Stifler testified that the search warrant of Defendant Gardner's iCloud was an attempt to locate evidence of ring videos, text messages, and financial information. I said, whoa, interesting. Ring videos. She said they knew they were missing information from the devices based on the other search warrant executions. Again, Stifler stated that law enforcement was instructed not to review the emails. When ATF Butler contacted her about the text message, ASA Stifler told her to stop the review and take it to the Taint team. ASA Stifler stated that she did not get any details about the message reviewed by ATF Butler. Do you guys believe that? Because I don't. On cross-examination of Stifler, acknowledged that the search warrants for the Defendant Gardner's iCloud and Defendant Fernandez's Google Drive did not mention using a Taint team. She stated that she only reviewed Defendant Fernandez's text messages. Next, the state called Agent Nazario to establish his Taint review procedures. Agent Nazario testified that he was instructed to remove anything attorney-client privileged. He stated that he removed material erroneously and reached out to ASA Stifler one time. Agent Nazario testified that he did not get any other direction from Stifler. On cross-examination, he was impeached on this fact. Woo! This is just music to my ear. What? Do you understand that this is the Secret Service testifying? And he says, on cross-examination, he was impeached on this fact. He was confronted with his prior testimony that he reached out to ASA Stifler 2 or 3 times for her opinion. On April 29, 2024, the state disclosed to the defense that ASA Stifler forwarded the June 30th, 2023 email from ATF Butler to the 2 other members of the prosecution team, ASA Maserati and ASA Wingard. On May 2nd, 2024, the court held an additional evidentiary hearing to address the recent disclosures by the state. The defense introduced the email disclosure and the email that was forwarded. Defendant Fernandez recalled Stifler as a witness, you fucking lying bitch. She testified that she was looking through her emails and discovered that she forwarded the email to to Maserati and Wingard. She didn't know. Wingard did not open the email based on a conversation with Stifler. Later that day, Stifler said that she did not see Mazarahi to ask him. While not called as a witness, Mazarahi represented to the court that he did not open the email. All hearings concluded with counsel's arguments. This court, being fully advised of the facts, evidence, and counsel's arguments, hereby makes its conclusions. Here it is. Okay. This court undertakes the defense allegations of the state's misconduct in potentially violating this long-standing privilege with great care. The allegations are serious, and the remedy sought is extraordinary. The court has the authority to disqualify the 4th Judicial Circuit State Attorney's Office. This is a question of whether the evidence substantiates the defense's allegations. The court is committed to the rule of law, which can be its only guide. The disqualification of a state attorney standard. Disqualifications of state attorney's office is a drastic measure, and trial courts should hesitate to impose it except where necessary. To disqualify a state attorney's office, a defendant must show substantial misconduct or actual prejudice. Both defendants claim disqualification is necessary because they have suffered actual prejudice in the form of privileged attorney-client communications being revealed to the prosecution. In the Fernandez case, there is no question that the timeline and text messages documents were attached to email communications between defendant Fernandez and his attorney. It is also undisputed that his attorneys instructed him to label any communications he intended only for his attorneys to see as confidential. These facts alone, however, do not make the content of the documents privileged. The court must analyze the content and the context of the creation of the contested documents to determine if it is privileged. I don't think you would need to do that because I thought it was blind. Anyways, the attorney-client privilege attaches only to confidential communications not intended to be disclosed to third persons who are not furthering the rendition of legal services. The attorney-client privilege exists to protect not only the giving of professional advice, but also the giving of information to the lawyer to enable him to render sound and informed advice. A client's confidential communication of facts to his attorney is protected by attorney-client privilege, even if the facts are discoverable by other means. Documents, however, which are given by a client to an attorney while seeking legal advice are privileged in the hands of the attorney only if they were privileged in the hands of the client. After an in-camera review by the court of both documents and emails provided by defendant Fernandez, it is clear the timeline is a responsive document that was part of a chain of communications between the defendant and his attorneys. It is also evident the document was generated from the defendant's personal knowledge at his attorney's instruction and solely to enable his attorney to render informed advice. Nothing suggests that the timeline was created outside of his attorney's direction or communicated with a third party. Accordingly, the court finds the timeline is privileged. Woo! Defendants don't ever win like this, baby. Come on now. Woo! Checking in from the beach, I have conspired with the bartenders and making sure she shows truth and transparency. We now have TNT. Drink, yes. I'm on my 5th, baby. Cheers. We're going to go ahead and give a shout out. Woo! I'm coming to the beach to drink too. I love their ice. Ice in a styrofoam cup is the best, especially when there's alcohol in it. God, I got so excited about my beverage. I forgot where I was. Love y'all back. She Beast. Where we going? Where we going bar hopping? Let me know. Let me know. You know, Carson's coming with us. She's diehard. We love our wine. Shit, we love everything. So there, you don't ever see wins like that, right? Now there's more to it though. Where the hell? Oh, here it is. Okay. So the timeline is privileged, right? William says it's Miller Lite time, baby. Yeah. So despite the timeline being privileged, attorney-client communication, defendant Fernandez failed to establish that he suffered actual prejudice from its exposure to the state. In violation of the agreement to use the Taint team, ASA Stifler was given a summary of the contents and possibly read portions of the timeline by ATF Butler. The court finds that ASA Stifler did not open or review the document when it was emailed to her along with the text messages. There is also no evidence of either of the two ASAs she forwarded the timeline to ever opening or reviewing the document. Based on the in-camera review of the timeline, the court finds that its contents would not support a finding of actual prejudice even if ASA Stifler had reviewed the entire document. Further, the state has represented that it does not intend to use the timeline or its contents against defendant Fernandez. Considering this, the court does not find the defendant Fernandez has suffered actual prejudice because of the timeline being sent to the state. Based on the court's findings that the timeline is privileged attorney-client communications and should have never been disclosed to the state, the timeline document is hereby suppressed. It gets better for the defendant. So the timeline is out. Anybody who wants to use it, you cannot use it. On the other hand, the text messages do not bear any of these same hallmarks of the timeline or an attorney-client privilege document. Instead, this document is effectively a repackaged data dump of defendant Fernandez's communications with a third party, defendant Tenon. The document has no commentary, editorializing, curation, or the like. Defendant Fernandez argues that he initiated the data dump through an application and that these messages cannot be found anywhere other than through his communication with his attorney, demonstrating the document is privileged. However, the court finds that text messages were not privileged in defendant Fernandez's hands, and there is no evidence that it was altered to include privileged information. Thus, there is no privilege to pass when defendant Fernandez sent them to his attorney. Accordingly, the court finds the text messages are not privileged, and he cannot suffer actual prejudice from the state learning of the content of the messages. In Gardner's case, ATF Butler came upon a message between defendant Gardner and her attorneys that ATF Butler felt contained privileged information. ATF Butler did not disclose the contents of the text messages. She contacted Stifler to tell her about the messages that she had found. Butler did not review or reveal the messages, and ATF Butler was instructed to stop reviewing the remainder of the data until Agent Nazario completed his taint analysis of the device. Thus, the state never learned about any of the privileged information in the messages, and therefore the court finds the defendant Gardner did not suffer actual prejudice. Now, just when I thought the text messages may get through, not so fast. Substantial misconduct analysis. The defendants have alleged that the state's violation of their discovery agreement is substantial misconduct, and the Fourth Circuit State Attorney's Office should be disqualified. In the instant cases, the defense attorneys for each defendant properly brought their concerns about the seizures of the devices and the content of those devices containing privileged information. The state assured the defense and the court that an order governing its examination of the evidence would not be necessary. In its order, the court addressed only the contested issue of marital privilege. and the attorney-client privilege issue ended up on a footnote. In the state's response, Mazarahi writes, in quotes, the case subjects involved an unusual fact pattern because generally, when the state downloads a suspect's phone or a computer as part of a criminal investigation, there are no attorney-client communications on the devices because there has not been an arrest and thus an attorney has not yet been hired, end quote. However, Defendant Fernandez and Defendant Gardner hired counsel pre-arrest and pre-indictment. They were active in communicating with their attorneys while the homicide investigation was ongoing. To me, that's not unusual. Both defense teams notified the state about the danger of examining the evidence like any other homicide case. The defense teams were diligent in their efforts to safeguard privileged information. They suggested using a taint procedure overseen by the court to protect privileged information. The state assured the defense and the court that sanitized law enforcement agents would conduct the taint review. Simply, that did not happen. The footnote states that the court believed both sides would work together. Again, that did not happen. The state and the defense are not required to work together to solve issues, though. However, it is incumbent upon the prosecutors to govern themselves about the conduct of other lawyers. Knowing that this case presented a unique set of circumstances, the state took an understaffed, ill-advised, and hyper-technical approach to the agreement to use a taint team. The court recognizes that while the state attorney's office may have had good intentions, the ultimate execution of this procedure resulted in the situation presented to the court. While law enforcement realized that there may be missing information on the devices, they secured search warrants on the internet-based storage accounts of both defendants. The returns for the search warrants were given directly to investigators for review. While attorney-client privilege information certainly would exist in an email folder, that is a narrow and dangerous view to take when the state gathered multiple terabits of electronic data from the defendants. In 2024, attorneys can use many ways to communicate with their clients. Defense attorneys can request and facilitate their clients to create many different forms of information that the privilege may cover. The investigator did not contact the taint agent, and she did not have an independent legal support. Inevitably, this resulted in the prosecutors conducting their own taint review for the taint agent and the investigator. The state argued that the agreement was only related to the devices, though. The court rejects this assertion. When the state failed to extend the agreement to the internet-based storage and the defendants did not know that the state was seeking this data, this foreclosed the defense from seeking court intervention as they did on the devices when they were notified of the seizure. So since we didn't know that they did it, we couldn't even come to you because they never told us that they were doing that shit. It is common sense, says Judge London Kite. It is common sense and prudent that the agreement should have extended to the information on the internet-based storage accounts. This digital data was a natural extension of what was on the seized devices and was sought partly because it may have copies of the data deleted from the seized devices. The state's approach to the agreement resulted in the highly probability that prosecutors and investigators would have access to attorney-client privilege information. As one could have predicted, not following the agreement and giving unredacted copies of the data to ATF Butler and other law enforcement before the taint agent completed his filter review quickly led to ATF Butler seeing unredacted communications. ATF Butler's avoidance of the contents of the word email and the email contents folder being the only care taken to prevent seeing privileged information was naive. You knew better, Butler. You're a graduate. You're UC Bearcat, man. What the fuck are you doing? Considering how internet-based storage services are used for both the creation, storage, and transmittal of data, attorney-client privilege information could have been and was contained in other storage areas. Upon being notified by ATF Butler that there were 2 potentially privileged documents she found in defendant Fernandez's internet-based storage, ASA Stifler could have immediately shut down her review. The court is confounded as to why ASA Stifler did not act similarly as she did in the defendant Gardner's case. Instead, ASA Stifler took the risk of determining whether the documents were privileged or not. Send them my way. I'll let you know. What? It is Fangirl Friday. And today we are definitely not fangirling over ASA Stifler. However, we are going to get to your comments soon because we are going to fangirl over you. Now, can you imagine a judge writing this shit about you? And just you're like, you're a lawyer. You've been doing this for a long time. We know you know what you're doing. And here, this judge is being, you knew better. You knew better. But here, she's trying to be as nice as possible, but still lighting Stifler's ass up. Instead, ASA Stifler took the risk of determining whether the documents were privileged. Now, to do this, Stifler needed ATF Butler to reveal the contents to her because no taint attorney was assigned. If Stifler was correct in her thought process that these documents were not privileged, then she would have obtained new, possibly relevant evidence. If ASA Stifler was incorrect, she could not unring the bell of her learning privileged information. Stifler admitted she chose this path instead of sending the documents to Agent Nazario because she knew this content blind review would remove both documents from the filtered return without determining if the content was privileged. Again, ill-advised. Had the state allowed court intervention in the setup, appointment, and oversight of the taint review, the question information could have been reviewed by the taint agent and identified for the defense as questionable information. If the defense wanted to restrict its disclosure to the prosecution based on a privileged claim, then the court could review it and rule. There would not be a fear of potentially relevant information being deleted because of the heightened level of content blind review that the state agreed would be the operating procedure. The accidental upload of the original files to the Next Point portal and the state's response shows that this was not the quote-unquote substantial misconduct of prosecutors warranting disqualification. To the state's credit, once it alerted that unredacted originals of the data were uploaded to Next Point and viewable by everyone, orders were immediately sent out to restrict all access. To her credit individually, Stifler also contacted attorneys for the defendant Gardner to inform them of the issue. There is no evidence that anyone at the state attorney's office accessed any privileged information via Next Point. There's no evidence of it. Okay. Wait till Next Point gets in. Wait till there's contact with Next Point. The evidence has shown, though, the defendant Fernandez and defendant Gardner seek extraordinary remedies for this state violating an agreement between parties. The court finds that the agreement was violated in a considerable way, though. The state has no credible argument that it abided by the agreement and has failed significantly in carrying out the assurances it gave to both the court and the defense. While the state's taint procedure was flawed in almost every respect and improperly executed, the court does not find the state attorney's office committed substantial misconduct to the degree that disqualification is necessary. Ultimately, disqualification is not a remedy for poor judgment. Clearly, the ASAs assigned to this case were unfamiliar with implementing a taint team properly and failed significantly. What a bunch of idiots. While the case law about the state attorney's disqualification does not clearly define what qualifies as substantial misconduct, it does shed light on what does and what does not. Now, after carefully considering the case law, evidence, and arguments of counsel, the court does not believe there was the level of substantial misconduct necessary to warrant the disqualification of an individual or the whole damn Fourth Judicial Circuit. It is clear from the testimony of Stifler that she realized that they had agreed to a filtered standard that was much more stringent than necessary. She took a poorly thought through chance in interacting with ATF Butler and Agent Nazar. The prosecution team limited the scope of their taint review, which led to law enforcement connected to the case in an investigative capacity seeing potentially privileged information. There was no evidence of nefarious conduct by the prosecutors. Instead, the court finds that ASA Stifler naively thought she could prevent law enforcement's exposure to privileged information by them to just avoid email folders. This amounts to poor judgment and not substantial misconduct. ASA Stifler minimized the lapses of judgment. There is no evidence that the alleged misconduct is attributed to any other ASA in the Fourth Judicial Circuit. To the extent defendants argue that the state's conduct has created an appearance of impropriety that only disqualification can remedy, that argument is also without merit. Alternative to disqualification, dismissal of indictment. The court finds that the dismissal of the charges is an inappropriate remedy and is hereby denied. However, alternative to disqualification, suppression. The court finds that defendant Fernandez is entitled to a remedy other than disqualification of the state attorney's office. The state is not without fault or blame for the issues presented by the defense. While the state's conduct does not rise to a level of misconduct that warrants disqualification, the court cannot ignore the actions of violating the agreement between the parties in such a considerable way. The court finds that based on the agreement, the state would not have discovered the text messages it intends to use against defendant Fernandez. The state agreed to the heightened level of content blind review for ATF Butler going through an unredacted version of the internet-based storage return. The state would not have the text messages as potential evidence. Oh my God. The court draws its sanction authority for discoverable violations from Florida Rule of Criminal Procedure. Suppressing the evidence obtained in violation of the parties' discovery agreement is a proportionate and proper remedy. This is what you do, Judge Hippler. If Judge Hippler would have been doing things like this, we'd probably have seen a trial. Judge Kite goes on to say, to the extent the court's suppressing the evidence obtained in violation of the parties' discovery agreement is proportionate and proper remedy. However, as with all suppressed evidence, if defendant Fernandez makes the text messages relevant during the trial, the court reserves the right to revisit its admission into evidence. As stated earlier, the timeline should be suppressed since it is non-discoverable privileged attorney-client communication. To the extent that defendant Gardner argues that the court should suppress all of her iMessages, regardless of the source, the court does not believe the state's conduct warrants suppressing that evidence solely for the purpose of punishment. The overall harm suffered by defendant Gardner from the state's violation of the agreement pales in comparison with the defendant Fernandez. Defendant Gardner did not suffer any harm from the review of the messages. The state acted appropriately and halted the review. However, the court finds that both defendant Gardner and defendant Fernandez are entitled to an actual filter process supervised by the court and properly litigated to resolve privilege issues. After a discovery case management hearing, the court will take the proper precautions to oversee the discovery in this case. Accordingly, it is ordered that the defendant Fernandez's motion to disqualify the Fourth Judicial Circuit Office of the State Attorney filed on November 15, 2023, defendant Shanna Gardner's supplemental pleading to motion to disqualify Office of the State Attorney and motion to dismiss the indictment for the violation of her Sixth Amendment right to counsel, prosecutorial misconduct, and outrageous government conduct on March 1st, 2024, and any adopted claims and arguments are denied. Additionally, the two documents, the text messages and the confidential information timeline, they are suppressed Holy shit! This is a huge win for defendant Fernandez, which will definitely help Shanna Gardner. Woo! Woo! Oh my God. After all that talking, these text messages are out of the trial. Text messages gone, out, suppressed. And guess what's coming? Way more stuff like this is coming because of the absolute horrid. I mean, you guys, they were after Shanna Gardner at all costs, and I think it's going to cost them. I personally believe that you're barking up the wrong tree. I think that we're going to find out in this case that ATF was brought in because of the names in this case that were flagged. And I'm telling you, Shanna Gardner's, you are crazy. You like criminals to walk free. What are you talking about? That's about our rights. If he is so guilty, trust me, you're going to get him. You don't need to violate people's rights. But for calling me crazy, you can go hang out somewhere else, cupcake. You do not violate people's rights. Okay? If Shanna Gardner had nothing to do with this, you cannot go and make shit up. You cannot lie. I personally believe that the evidence it's going to show is that Mario Saldana Fernandez, whatever the fuck he wants to call himself these days, if Shanna Gardner was leaving him and divorcing him, he's out his cush little lifestyle that he would have had. Okay. Also, Shanna Gardner, you're going to have to show that Shanna Gardner was involved and that in terms of like, yep, she was meeting up with these ridiculous people. Mario Saldana is going to come out. He was a controlling, abusive son of a bitch. Okay. And he was hanging out with ex-cops, John Biggerstaff, his son, John Biggerstaff's son. They were involved in some sex trafficking shit. That's going to come out. Wild shit's going to come out. But for the ATF to be involved day one after this tells me that names were flagged and it wasn't Shanna Gardner's name. It would be names like Mario Saldana, John Biggerstaff. Henry Tenen recanted. I have no idea what he's going to say now. They're saying that there are 5 people, but 2 of the people are co-conspirators, but they are not indicted. They wanted to indict 62, 52-year-old women because of jokes in text messages between people talking about people's exes. And oh God, can you just give me some of those funeral potatoes? And can we get a magician here to make him disappear? Do you know a magician so you can make him just disappear? Yeah. So long, cupcake. Look at that. Look at that. Text messages gone, though. Out. Suppressed. I believe that the gun that was used to kill Jared Bridegan is going to come up, that it was a 10 millimeter, and that John Biggerstaff had that type of a gun, that he bought it in Georgia and somehow transported it here to Florida. He bought it in 2016. And it's like, well, that gun wasn't bought for the purpose to kill somebody that he didn't even know he was going to be killing or being involved with killing in 2022, right? So I can't wait to hear more about of how this all truly went down. You know, because why in the world would you ever set up an ambush killing for right after the kids would be dropped off at your house, meaning you're going to have direct knowledge of that person's schedule, and it's going to implicate you right away. Okay. And to me, this just seems like Mario Mario conducted this, was involved with this, and it was to keep Shanna Gardner and keep that money coming in from the trust and all this other shit, so he didn't have to work and stuff like that. Because if she's divorcing him, then he's out, you know. So Mario was like, okay, well, if I do this, then I'm telling you, wait for it. Wait for it. Please let me know what you guys think in the video. But those text messages will not be coming in. Don't know what they say. Don't care what they say. The constant lying has to stop. And Jose Baez, I stand with what he says here. Ask the tough questions.
Ambiguities, that they clear them up immediately, that they explain why they didn't record that meeting, why they didn't file a police report on that meeting, why Detective Johns is lying about speaking to a person when in fact he actually did, lying as to why she changed her number when in fact she still to this day has not changed her number. There's no reason any of these things could have had to have occurred in this case. If they really have a case, if their case is as open and shut as they say it is, to the point where they're confident enough to seek the ultimate penalty of death, then none of this should be going on. None of this. And the fact that they expect us to stand by and let it occur just isn't going to happen. Just is not going to happen. And I ask that all of you ask the tough questions. And by all means, if you want to ask me questions, I noticed Mr. Mizrahi left. You know, he doesn't want.
Yeah, he doesn't want to get asked the tough questions. Mr. Mizrahi, Mr. Miss Stifler, Mr. Mizrahi. Go, Jose. You go, man. We'll ask the tough questions here. This is Truth and Transparency. We love you. Thank you so much. Peace out. Peace out. We'll see you soon. Mr. Mizrahi. Miss Stifler.
Answer to his actions. So it is what it is.